Good afternoon, folks, and welcome to this week's episode of the Legal Beagle podcast. We are in the new Legal Beagle library. Look, we're surrounded by leather-bound books and rich mahogany furniture. We have really changed the game here, and I hope that you enjoy the Legal Beagle podcast coming to you from the Legal Beagle library. Yet to be sponsored, although I have a feeling at some point it will be. This week, I want to talk to you guys about a new enterprise that has come into Phoenix and is causing all sorts of problems for you, the injured party related to an accident claim, and you, the attorney representing that injured party. The company, the enterprise, is called ClaimTECH. ClaimTECH is a company out of Texas, and they are, I want to read to you what it says on their website. You can go to claimtech.com. They say they're the global leader in medical bill resolution. ClaimTECH facilitates high-speed transactions that optimize the resolution and outcome of both first and third-party liability medical bills worldwide. What does that really mean? Let's unpack that. What's really occurring here is this company, ClaimTECH, and the insurance industry have engaged in a scheme to try to undermine the true value of your accident claim. If you aren't aware, I want to make sure that you are aware, the measure of damages, meaning what is your claim worth, is a itemized list that can be found by going to the Arizona State Bar page, and you can find different damages. They're called revised Arizona jury instructions. And in personal injury cases, there is 6 different things that are listed as your measure of damages related to an accident. 1, the nature, extent, and duration of your injury. 2, the pain, discomfort, suffering, disability, disfigurement, and anxiety already experienced and reasonably probable to be experienced in the future as a result of the injury. 3, reasonable expenses of necessary medical care, treatment, and services rendered and reasonably probable to be incurred in the future. And then it goes on. 4 is about lost earnings. 5 is about loss of love, care, and affection and companionship. And then 6 is loss of enjoyment of life and your ability to participate in normal activities. So let's focus in on number 3, because that is what ClaimTECH is trying to take out of the measure of damages related to your personal injury claim. Reasonable expenses of necessary medical care, treatment, and services rendered, and reasonably probable to be incurred in the future. What does that mean? Your medical bills. So you go to the ER after an accident and you don't have health insurance. So the medical team there at the hospital gives you medical care, and then the medical billing department says, look, you were in an accident, so we're going to record what's called a medical lien against your case, and we're going to wait for you to resolve your accident claim, and then we're going to get paid out of that accident claim. That is one of the damages that you are entitled to as an accident victim. As an attorney representing these people, we all know that a settlement or a verdict at trial is one lump sum. It may be a combination of these 6 things that you see in the revised Arizona jury instructions. It may be some or not all of them based on the claim, but you get one final amount that is awarded by the jury, or a verdict is given by the jury, and then you settle your case and you have one amount that you have to use to pay legal fees, legal costs, medical bills, any other outstanding money that may be owed related to the claim, and then the client gets the rest of that. Now, that's an important part of the claim handling process, because There's a lot of moving parts that influence what the client is going to end up receiving. This company, ClaimTECH, has come in, and they've been doing this for a while out of Texas. They've come into Phoenix, into Arizona, so it's not just exclusively Phoenix, and they're trying to take away the measure of damages as it relates to your medical bills. Here's where it gets really tricky, and you need to really understand this and pay attention. What ClaimTECH is doing is they're contracting with the insurance company to say, look, we're going to go resolve these claims sometimes without even the injured party knowing about them, which could pose its own HIPAA violations and challenges there as it relates to what's legal and what's not when a third party is now interfering with your claim that is being made against a at-fault party that would be represented or covered by some insurance company. So you have this company coming in and saying to the insurance company, look, insurance company, we're going to go resolve these medical bills before you even settle the claim with your claimant, before the injured party. Before you even settle that claim with the injured party, we're going to go resolve these medical bills. That way you don't have to pay those medical bills as part of the total measure of damages. So they're trying to change the revised Arizona jury instructions. They're saying to these auto insurance carriers, the way we make our money is we get a percentage of whatever we're able to reduce that bill by. Because if the bill for the ER is, let's say, $10,000, if they go into the ER and say, we'll give you $3,000, and the ER accepts that, well, there's a $7,000 savings there for the insurance carrier. And ClaimTECH then gets a piece of that as their fee for going ahead and resolving these medical bills ahead of time. Not all medical providers are on board to do this. And I would tell you that if you are an attorney representing injury victims, that you need to be aware of this company and you need to dig into what they're about and make sure that if you're dealing with companies like American Family, Liberty Mutual, these are a few that have contracted with ClaimTECH, that you talk to your providers and you talk to your client to make sure they are informed about this possibility. Let's look at this from two different angles. First, if you are the injured party and you are treating at, let's say, a physical therapy facility, and you get done with treatment, and then your attorney puts together what's called a demand package and sends it over to the insurance company, which is a collection of all of your medical bills, all of your lost wage information, any other damages that you may have experienced, including that loss of enjoyment and the limitations that this injury may have had on your life. All that sent to the insurance company, and then a negotiation may begin with that insurance company. Well, the insurance company, if they've contracted with ClaimTECH to go resolve some of these bills, will say, well, we don't have to pay for that physical therapy because that's already being handled by ClaimTECH. Here's the problem. That physical therapy company may get an offer to resolve the medical bill for your client, but they may not accept it. It's going to be significantly less than the full value of that bill, which they are entitled to the full value of their bill. It's not like there's a mandated discount or reduction that these providers must engage in, absent a few exceptions based on some case law. But the majority of these liens, these medical liens, need to be paid, and they need to be paid in full. And so if your provider says, let's use that physical therapy facility, they say, no, ClaimTECH, we're not taking a third of what we're owed. We want the full balance. Well, now the insurance carrier and ClaimTECH are stuck because they've agreed to resolve that for you and they can't get it resolved. So what happens in that situation? You, the client, may be sued by your healthcare provider. In the example I'm using, that physical therapy facility could sue you for the full balance of the bill owed because you sign an agreement with them when you go in to treat that says, I understand that I'm not paying up front and I don't necessarily have health insurance to cover me, but I do have to pay this bill. I am ultimately responsible for this bill. So if it's not resolved by way of ClaimTECH or these insurance carriers, you're on the hook for it. You could literally settle your claim and then have to come out of pocket to pay your providers after the claim has been resolved and lose money as a result of this behavior and this new enterprise that ClaimTECH and the insurance carriers are trying to engage in. So you need to be aware of that possibility. If you sign a release agreement, most release agreements indemnify the insurance carrier against any further action that you would have on their behalf or against their insured and against the insurance company. Meaning, if you were to get sued and you were to go back to, let's say, American Family and say, hey, American Family, you guys said you would pay this and you didn't. What's going on? You need to defend me in this. You need to take care of this. They could say, nope, you signed a release agreement. We're off the hook. They literally could box you into a situation where not only do they say they're going to pay something and then can't engage in some sort of compromise with the healthcare provider, but you could end up being sued by your healthcare provider for a balance that is owed to the healthcare provider by you, the injured party. That's a terrible situation to be in. And that's why hiring an attorney and making sure you have a person representing you that is both educated, that understands these things, and can navigate this complex little web of deceit that ClaimTECH and these insurance carriers are trying to engage in. If you're an attorney representing these injured parties, my recommendation, what we're doing at my office, is we're making sure to let providers know of our involvement and our willingness to work with them. And if they record a lien and it's valid and it's a lien that is allowed by law, then we have to ethically consider that as part of the case resolution. But more importantly, what we don't want providers to start doing is taking pennies on the dollar to try to negotiate a bill ahead of any sort of case resolution, because that may jeopardize the healthcare provider and say, well, look, healthcare provider, you're taking a third of what you were owed. What if the recovery allowed you to be compensated to 100%? Why would you do that? And so you have to have good relationships with your healthcare providers. You have to have consent from your client to make sure that you can have some of these conversations, because your client is the person that you answer to, not necessarily the healthcare provider. So you have to make sure as the attorney that you are fully informing your client, talking to them about this new enterprise and making sure they understand what's happening here. From what I understand, the chairman and CEO of ClaimTECH is a gentleman by the name of Kent McCree. Mr. McCree, if you hear this podcast, if you watch this video, contact me. I'll invite you on. Let's hear your side of the story. Let's hear why you think this is a good thing for injured victims as it relates to their accident claims. Not a good thing for your company, not a good thing for your bottom line, not a good thing for the insurance industry, a good thing for you. Or, excuse me, a good thing for the people that are being injured. If you can prove to me that this is a good thing for the people that are being injured, I'm willing to hear you. But as I see it right now, what I see happening, I don't think it's a good thing. I think this is a scheme that you and the insurance industry are engaging in to try to cheat people out of their fair recoveries. So I'm calling you out, Kent. If you hear this podcast, contact me. If not, continue to lurk in the shadows and try to do this behind the scenes, because that's what you guys are doing. We find out about this after you've already started these conversations and then get contacted by either a provider, by a client who may have learned of these transactions. But it's not like you and the insurance industry are being transparent. You're certainly not sharing this information with anyone. You're being found out, and it's creating all sorts of damages. I want to know how you're getting a hold of my client's health insurance information. There are laws that protect my client from the exposure of their health insurance information. So I want to know how you're getting that. Can you tell me that, Kent? How are you getting the information in the first place? Because if you're getting it through the insurance company, that could be a problem. Just because my client was injured and they've put some of their injury claims at issue in this case does not give the insurance company nor any third party the right to those records and bills without some sort of consent from the injured party. And it doesn't seem like that's happening here. So I'd like to know that. I'd like to know exactly what these contracts between you and the insurance company say and what kind of fee structure or payment structure is happening on the back end. As I said earlier, I suspect it is some sort of arrangement where you collect a part of the reduction that you're able to obtain. And then finally, I'd like to understand, outside of the HIPAA violations and the potential tortious interference claims that are likely to occur if this practice continues, I just fail to appreciate how this benefits anyone but ClaimTECH and the insurance company that is engaging in this absurd practice. And it's absurd. It's not what the revised Arizona jury instructions say is the full value or full measure of damages related to a claim. It certainly is a workaround by you, a concerted effort between you and the insurance industry to save the insurance industry money and make money off of that savings. Think about that for a minute, folks. If you're listening to that, I'm going to say that again. ClaimTECH and the insurance industry are engaging in a practice to save the insurance company money, and ClaimTECH is making money off of those savings because you were injured in an accident. I can't even unpack that without getting furious. The fact that there are people out there trying to take advantage of injured parties, take advantage of healthcare providers that are doing good work to help people get better, and conspiring with insurance companies to try to cheat people out of fair recoveries, it's appalling. It's appalling. I'd like to call out a couple other people. Ty Morrell, M-O-R-R-I-L. He serves as the Director of Operations for ClaimTECH. So Kent, Ty, reach out to me. Let's do a podcast. Come on. If you're not embarrassed by what your company does, if you think that what your company does is completely above board and doesn't hurt anybody, then come on. I'll let you tell your side of the story. If not, then we're going to continue to find ways to expose this practice, let people know so they're fully informed, and make sure that healthcare providers are aware, that clients are fully educated on the possibility of this happening, and ultimately bringing claims against your company and the insurance companies that you conspire with to further this practice. That's all I've got. That's all I've got. This was a call out to a terrible new enterprise that has come into Phoenix, Arizona. And I feel, as a plaintiff's attorney, as someone who represents injured parties, as someone who deeply cares about getting the full measure of damages for those that were victims of an accident, I feel that you need to know about this sort of practice. You need to know about what's going on. And I certainly wanted to do my best to educate you and call out ClaimTECH. So until next week, folks, thanks for joining.